interrupt.
Madam Chair, can I finish my response?
Precedent. Minister
order.
Varani, this is my time.
Point of order.
Excuse me. It's very difficult for the interpreters to interpret when you talk over top of each other. So, Mr. Brock, I'll set you back to 45 seconds. Can you just shorten your question so we can get an answer in?
Mr. Varani, there is ample precedent of numerous governments, including this particular government, to have waived legal opinion, to have waived solicitor-client privilege. If the Prime Minister, to Justice Rouleau, was so serene and confident in his decision to invoke the Emergencies Act, in light of Justice Mosley's repudiation of the invocation of that act, what is the government hiding?
Briefly, please, Mr. Brown.
I would say solicitor-client privilege is foundational to the development of legal advice in a candid and frank manner between a solicitor and their client. It is a sacrosanct privilege that has existed for centuries in British common law, and it is one that this government firmly believes in terms of producing.
And you, sir, have the
legal
position
advice.
to waive that privilege.
We'll now move to Mr. Maloney. 5 minutes.
Thank you, Madam Chair. I appreciate that opportunity. And ministers, other witnesses, I really want to say how grateful I am for you being here today, especially it's an evening meeting. My question, I guess, is for both ministers, but perhaps Minister Varani, it would make sense to start with you, given your background in this committee. Look, I've only recently joined this committee. In fact, this is my third meeting. You said you look back fondly on this. I look forward to the day that I can look back fondly on this committee. But unfortunately, as we've just witnessed, this committee has become highly politicized, and it's lost its way, frankly. If you look at the Emergencies Act legislation, there's two things. There's this committee and there's the Royal Commission. Both of them are put in place for very specific purposes. One is to look at the conditions that were in place that it required the government to invoke the legislation, and one, which is this committee, is to look at what goes on during the time when the committee or the legislation had been invoked, or the Emergencies Act had been invoked. We're about 2 days away from 2 years, two days away from the 2-year anniversary when it was invoked, and a few days away from 2 years from the anniversary when it was revoked. Now, I would say that this committee has gone far beyond its scope and far beyond its mandate, and I would like to hear your view on that, and perhaps Minister LeBlanc, too.
Thank you, Mr. Maloney, for the question. I'll say to you, my interpretation of the statute as it's plainly written was exactly the same when we first commenced at this committee, and many people who are members of this committee made the exact same argument that this was meant to be an oversight during the period of the invocation of a declaration. I think at this point we are where we are, but what I would say to you is that there still is, it's unfortunate and somewhat ironic that something that was commenced after the constitution of this committee, the Rouleau Commission, has concluded before this committee has even wrapped up its work. But I think there is still ample room for this committee to do the important work that a joint Senate, House, multi-partisan committee can do, which is actually provide recommendations. And providing those on a timely basis, as in very, very soon, would be helpful to the deliberations of all parliamentarians in terms of reflecting on the invocation and reflecting on the way forward.
Okay, maybe, look, I mean, you just had a discussion with Mr. Brock about the production of the opinion that was provided with respect to the invocation of the Act. Leaving aside the issue of solicitor-client privilege, I think that discussion is a glaring example of how this committee has gone beyond its mandate, because given the terms of reference for this committee, that opinion has no relevance here whatsoever. So my next question really is in terms of Minister LeBlanc had suggested he's going to have some response to Justice Rouleau. The two of you, particularly you, Minister LeBlanc, are going to put forward some proposals on how the legislation can be improved. Unfortunately, we might be in a situation where you don't have a report from this committee. So I'm wondering if you have any thoughts about how the legislation could be reviewed now, and would one of those proposals include redefining the scope of this committee in terms of a time frame so we don't run into this situation where we go beyond its scope, beyond the time, and turn the committee into something it was never meant to be?
Madam Chair, thank you, Mr. Maloney, for the question. My understanding of the statute, what I was briefed, following the invocation and then rescinding the invocation. I thought my understanding of the role of this committee was as you described and as my colleague Arif, I think, also endorsed. Next week, I will set out the government's response to all of the Rouleau Commission recommendations. You properly noted, Mr. Maloney, that he does, in the Commission report, make suggestions around potential legislative amendments, some around the Emergencies Act, the definition of in the CSIS Act. Those are complicated undertakings, and I think the government and Parliament would very much benefit from the advice of this committee, because it's a committee representing both houses of our Parliament. I think there's a unique opportunity to hear from parliamentary colleagues on how Parliament may consider those legislative amendments. I'll be setting out specific government responses to some of the more administrative, police of jurisdiction issues that the Commissioner identified. And as you would know, a number of the recommendations also touched other orders of government. But we will be, I hope, providing a detailed response, as we committed to do. But I totally share your view, if I understood it, Mr. Maloney, that it would be certainly helpful, I think, to Parliament to benefit from the view of a committee of parliamentarians that has studied this issue in terms of, are there legislative steps? The Emergencies Act, as we heard, is a piece of legislation that's almost 4 decades old. The first time it had been invoked, so it would be a thoughtful exercise, I think, that would benefit Parliament.
Time is up.
you.
Mr. Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. First of all, welcome, everyone. Welcome to the ministers and to all our guests. A question for Minister Virani. You were saying earlier that we've been sitting for quite some time, and the Rouleau Commission has already given in its report. You were here in June 2023, and you'll remember that we voted for a motion requesting the translation of all documents before the Rouleau Commission. What would you say if I told you that today, 9 months later, we still haven't received any of those translated documents, and the PCO hasn't even started working on that translation project? I can't really speak to that. I remember when this was raised in June, and what about the delay, Mr. Minister? 9 months later, nothing has been done. Are you surprised by that? I have no information on the topic. I think you should ask the witnesses who appeared before us. Thank you. Minister Virani, you say that the decision to invoke the act was made based on the information we had. Now, Minister Leblanc, you were in cabinet when the act was invoked. Do you agree that it was based on the knowledge you had at that time? Absolutely. We discussed the issues broadly in different forums, and we came to a decision that we believed was reasonable and legal based on the information we had at that time. You know that at this committee, this all happened 2 years ago, and we were struck a year and a half ago. And the evidence that we heard, well, I didn't hear anything that seemed to justify the invocation of the act. The blockade at the bridge was dismantled before the invocation of the act, and then there were trucks downtown, of course, but the chief of police, Mr. Soli, came to speak to us to say that he had requested a certain number of police officers to dismantle the blockade here downtown, and it happened after he had left. Now, I don't really understand what the justification was. It seems to me that invoking the act was a little excessive. The only thing that I wonder is all ministers who've appeared here say, look, I understand, but we based our decision on a legal opinion that we were given. So do you agree with what your predecessors have said, that you cannot share that legal opinion with us? Are you able to justify the invocation of the act by letting us see the legal opinion? I rely on what my colleagues said when it comes to the legal opinion. Honestly, if you had been in cabinet during those discussions, personally, I was persuaded through our discussions with law enforcement. Sorry for interrupting, we don't have much time. The commissioner said that she had not recommended invoking the act. I don't want you to spend too long on that. No, I don't want to spend time on that. But what I wanted to say is the issue of whether there would be other events like what we saw in Coots in Alberta, what we saw at the Ambassador Bridge. We didn't have enough confidence in the fact that there wasn't a risk of more violent events occurring. We also were in communication with Ontario. Forgive me, we only have a few seconds. Are you saying that you invoked the act as a preventive measure in case other events occurred? I don't want to insult your intelligence, but I'm sure you were convinced it was the right thing to do at the time. But I'm asking you to explain this to us, because that's our job here. Nobody is willing to explain it to us. Well, we explained it. Several senior officials and ministers explained it during the Rouleau Commission for hours at a time. It was televised live, and Justice Rouleau concluded that it was legal and justified. But can you send us the legal opinion?
Merci, Madame la Présidente.
Mr. Green?
Thank you. Minister LeBlanc, you opined on the scope of this committee and our responsibilities and the timelines in which, we've taken on coming ultimately to hopefully some recommendations in the near future. And yet the Rouleau Commission accorded you 12 months to respond, and that deadline is passed. Why?
Because, and as I said, I will have detailed responses as is appropriate, of course, to the Commission's recommendations. We wanted to, in light of the federal court decision, we wanted to ensure that the government response would take into account the trial division decision, and we wanted to ensure that as we were responding to those recommendations, it would be done in a way that would be consistent with the government's decision also to go to the Federal Court of Appeal on that decision. So, but for that court decision, we would have done it last week or this week. Good news is I'll be happy to do it next week. And in part of that report, will you provide an explanation for the changing nature of your definition of a threat to security of Canada, as is recorded under Section 2 of the CSIS Act? And it's an issue that the Commission raised. It's an issue that I know has been discussed at this committee. And our response, as I said, will detail the government's specific response to all of the recommendations of the Rouleau Commission, including his suggestions around legislative change. Mr. Vigneault, have you undertaken any work at CSIS to provide input or memorandums or any kind of background briefing documents to Cabinet relating to your organization's position as it relates to Section 2 of the CSIS Act in accordance with the parameters set out for a threat to national security?
Madam Chair, we have done work on Section 2. We have been doing work on a different aspect of the CSIS Act for years. And when the government comes up with its decision on the responding to the Rouleau Commission report, we will be able to advise the government and provide our analysis in due course.
Mr. LeBlanc, I would put to you that at this point, we still haven't heard, in my opinion, an adequate explanation from the government
on its use of that definition under the Act, and now we're hearing in other bodies that they've expanded the use. They've perhaps provided some editorial expansion on the definition of a threat to national security. But I can share with you that despite all the meetings and all of the witnesses that we've had here, I've yet to hear anybody clearly articulate the government's rationale for changing that definition. Will that be included in the Rouleau Commission report, specifically that point? Your report back as
our response to the Rouleau Commission report, yes. Well, again, I know people will be very excited to see the government's response to the Rouleau Commission, and the good news is it's coming soon. And as I said, we think Justice Rouleau did an important, exhaustive
Mr. LeBlanc,
work.
sir, please. We've been at this for quite some time. I'm asking you a direct question. I'm going to ask for you to provide a direct response.
So I'm not going to tell you what's in the government response to the Rouleau Commission. I'm telling you if
Okay, so, sir, what I'm going to put to you is that this committee has a responsibility. We've heard Mr. Varani and many people come before this committee talking about client solicitor privilege. We had that conversation today at Ethics. We heard him say it was sacrosanct. I would put to you that the powers of Parliament supersede that in our ability to send for documents and get information. So if it's your position that you're not willing to testify on a very basic answer tonight, are you then prepared to come back to this committee in 2 weeks? And are you then prepared to be a part of a process that prolongs this committee rather than just answering a very straightforward question, sir?
You've asked about 4 or 5 questions.
It's one question.
You say is a straightforward
It's one question. Let's not dance around it.
You said that I wasn't prepared to testify about that tonight. What I said is I wasn't prepared to talk about the government's detailed response to the Rouleau Commission report.
It's not what I asked.
Until we talk about it publicly next week.
What I asked was, will that be included? Will it be included? That specific parameter.
The government will respond to every one of Justice Rouleau's thoughtful recommendations.
Mr. Varani, is it your contention that cabinet confidence is supreme and superior to the Parliament's privileges here as accorded through long jurisprudence within the House of Commons?
I'm glad you raised cabinet confidence, because I think it's important to understand, because you have raised this and Monsieur Fortin raised it, but the functioning of a parliament and our system of parliamentary democracy as it's been inherited from the Westminster model includes cabinet confidence. So we're not just talking about solicitor-client privilege materials, we're talking about cabinet confidence, which exists to promote open and candid discussions around the cabinet table in the public interest that will be fearlessly advanced at that table and then defended.
Mr. Varani, as you would have heard in my previous testimony, and we've had these discussions, and you're a very learned lawyer, you're the Attorney General now, that despite that assertion outside and within the courts, inside Parliament, would you not agree that the Constitution states that Parliament has the power to send for people documented information that would supersede this notion of everything being client solicitor privilege?
Mr. Green, your time is up.
There's 10 seconds left, is there not? No?
Not according to mine.
Oh.
But I am next, so Mr. Green, will you take the chair?
Happily.
And Mr. Varani, I would ask you to take the opportunity to answer his question.
So I agree that Parliament has the power to make the request. I do not agree about it superseding necessarily cabinet confidence. Cabinet confidence is waived very rarely.
Thank you. I'd like to go back to Mr. LeBlanc's report we may see next week around the recommendations, and you can either respond to this or perhaps the Commissioner can. What emphasis or what may we see around the role of layers of policing, particularly around this city where residents raise major concerns about the delivery of police services?
Senator, thank you for raising that, and maybe the Commissioner will want to add something. That was absolutely one of the takeaways of the Rouleau Commission, the confusion that existed in terms of who had jurisdictional responsibility on Wellington Street, the Parliamentary Protective Service. All of you know this probably better than I do. But when I read the Rouleau Commission report, his focus on the clarity as between the different polices of jurisdiction, the role of the RCMP, the Ottawa Police, the Ontario Police Services Act. It was a discussion that I remember having with Premier Ford. So we will have something very specific to say about that next week, and we hope that it will be, we think, a rather full answer to that challenge that Commissioner Rouleau identified, and we've worked on that for the last year. But maybe Commissioner Duhem wants to add something on that specific issue as well.
I can just add, Madam Chair, that since then we've seen a difference in requesting for resources. And I think there's a historical part here that needs to be understood as well. When the RCMP was responsible for the Hill, we worked jointly with Ottawa Police Service because most of the demos would start in the street and end on the Hill. And when PPS took over, the RCMP was no longer present. And that reflex of calling the RCMP and assistance was still there. And now I'm happy to say that the first call for assistance for additional resources goes to the OPP, for Ottawa Police Service, goes to the OPP. And if for some reason Commissioner Carrique cannot supply the resources, they'll come to the RCMP.
Thank you. And so would it be fair for me to assume that the police agencies, the heads of the agencies that were involved, Ottawa, the OPP, and the RCMP, have actually done a debrief of the situation? Because it appears to me, and you know I have some understanding of the issue, that despite the provincial concerns that were expressed, there did not seem to be much communication. I'm not talking between police services, I'm talking between governments on the actual decision-making throughout the event. So I think we heard evidence here, and we attempted to have representation from the province here. They were not. They refused to come. And so I'm curious as to if I'm an Ottawa resident, I'm sitting here next week, can I expect that the reply that will be given out next week will include and erase my concern about what we saw take place?
Are you talking from a law enforcement perspective? Because you mentioned also government not talking to each other.
Well, it depends how far you think they're separated, but yes.
So from a law enforcement perspective,
yes.
We are in a different place that we were when Convoy happened, and we've seen it through different events that took place in Ottawa. From a government perspective, I'll let Minister LeBlanc respond to that.
Very, very careful dodging there, Mike. That was well done. But Senator, again, I think that one of the thoughtful findings of the Rouleau Commission, his phrase that was often repeated was a failure of federalism. Whether that was in the report or in comments that he made around the release of the report, we certainly took note of that and recognized that for those residents in Ottawa during those weeks, they would not have understood, as between the municipal order of government, the province of Ontario, and the government of Canada, there wasn't a more direct way to sort out that exact contradiction or confusion that I think you properly identified in your question. I know that during those weeks, my colleagues, the then Public Safety Minister, was talking to his Ontario counterpart, the Solicitor General, the Transport Ministers were speaking. I was talking to Premier Ford as the Intergovernmental Affairs Minister at the time. But we do think that there needs to be a more structured way in those exact circumstances to remove sort of the hesitation if it's one order of government or another. The citizens wanted that situation resolved peacefully and quickly, and it took way too long to do that. And I think next week we're going to have something to say about the structures that both the Commissioner referred to, the law enforcement, obviously structures that he can speak to, but we recognize that it has to be sort of the whole of government needs to recognize its relationship with partners.
Senator Carignan, you have 5 minutes.
Oui. Ma question s'adresse aux deux.
My question is for both ministers. Do you have anything to hide?
Plaisir de vous voir, Sénateur.
It's a pleasure to see you, Senator. No, I don't. Then why don't you provide us with a legal opinion? Can I answer, Madam Chair? Because it is subject to solicitor-client privilege. Okay, fine. I'm a lawyer. I remember. I spent a lot of time studying privilege, but who's it in favor of? The cabinet, the client, the client. So why doesn't cabinet simply revoke that confidentiality? I think you two probably have a lot of power in cabinet. What are you waiting for to provide us with a legal opinion? Mr. Minister, you say Justice Rouleau decided this, decided that. He studied everything, but he did not study the legal opinion. It was refused to him. So there are two things. Either it's legal or it's unlawful. Forgive me, but every time the senator hits the table, it can harm the interpreter's hearing. My apologies. What are you waiting for? If the legal opinion is lawful, then share it with us, and we'll clear it up immediately. Mr. Senator Carignan.
You would appreciate that it is not the contents that we're trying to protect. What is critical in protecting solicitor-client privilege is a relationship that existed, as I mentioned, for hundreds of years between solicitors and their clients, which promotes candor and free and full and fair advice. Understanding that that privilege is sacrosanct between that professional and their client. It is important to the functioning of law in this country and in British common law.
Don't talk to me that way. I feel like you are taking me for a fool.
Madam
Please
Chair?
do, and then Senator
J'en ai des
Carignan.
clients.
So the point
J'en ai eu
is,
des clients. Si le client
I guess
me
I'm not
dit,
able to finish,
si
Madam
Senator
le client
Carignan.
me dit, vous pouvez parler,
Senator
donner
Carignan.
l'opinion juridique.
If a client tells me that they are breaking solicitor-client privilege, then it is broken.
I remember fondly your frequent references to Supreme Court case law at this committee, Monsieur Le Carignan. The Supreme Court in case law has actually attributed this, and I'm reading from a
donc
case
j'en
called
conclus.
McClure, that
J'en
this
conclus que vous voulez la
ensures
cacher.
vitality of full
I conclude
between those who need legal advice and those who are best able to provide it. The
Point of
resulting
order,
confidential
Chair.
relationship between the solicitor and client is a necessary and essential condition of the effective administration of justice. That's the Cour suprême du Canada.
OK, donc vous la cachez.
I've got a point of order.
Madam Chair,
Those are your words,
maybe it's a function of people talking over each other, but I know that the interpreters are having a very difficult time translating the exchange. And when they have difficulty, we lose out. Those who
Couldn't
don't
agree with you
understand the
more.
French language, I would have loved to have fully understood what Senator Carignan was putting to this witness, but I wasn't able to.
Okay, so
Translation was not able to keep up.
I totally agree. May I ask all committee members and the witnesses to refrain from speaking over each other, allow the witness to answer, and then ask the question. If you need it shortened, you can indicate that. So, Senator Carignan, you have 1.5 minutes left.
Donc j'en conclus que vous avez quelque chose.
So I can only conclude that you have something to hide.
Have that on the record,
Pouvez-vous
Madam Speaker.
m'expliquer que
Can you say the emergency measures were essential? There's a note here, Jacqueline Bogdan, Vice Secretary, and they sent this to us after we requested this. Daily report, 11th of February, 8 a.m. A few people are on Wellington Street and surrounding streets. February 12th, 8 a.m., 0 to 5 people on Parliament Hill, a small number of people on Wellington and surrounding streets. February 14th, 8:13 a.m., nobody on the Hill, nobody on Wellington or neighboring streets. And then you invoke the Emergencies Act? Madam Chair, I remember Ms. Bogdan. She's a senior official at PCO. I haven't seen the document that Senator Carignan was citing. I was part of the incident response group. There were several officials describing a dynamic situation in several jurisdictions. I'm not sure how many people were on the street corner on Wellington 8 a.m., but I'm very comfortable with the decision the government made.
Senator Harder.
Thank you very much, Chair. Colleagues, I think while we're 2 weeks after Groundhog Day, we're very much practicing the Groundhog Day theme by revisiting stuff that Mr. Virani, you participated in as a member and now as a minister. As a resident of Ottawa who was here during that whole episode, my question 2 years ago was, what took you so long? And my question today is, I'm on the appetite, Minister LeBlanc, of your announcement next week. Will that include commitments with respect to Wellington Street? Could you tell us whether or not there have been any consultations at the provincial level so that your statements of next week will reflect joint efforts, or is this a unilateral announcement?
So, Madam Chair, through you, thank you, Senator Harder, for the question. And I, too, was in Ottawa, not a resident of Ottawa, but I was in Ottawa during those weeks myself. And I certainly shared the sentiment that you expressed. And we all have friends and family members that witnessed that circumstance as well and came to the same conclusion. The response next week will be the Government of Canada's response, obviously, to the Rouleau Commission recommendations. Some of those recommendations were properly directed at other orders of government, as you noted. I don't purport to think that the Rouleau Commission will deal with the long-standing issue around Wellington Street, the jurisdiction of Wellington Street, the role of the City of Ottawa, the parliamentary precinct. I know that some of my cabinet colleagues, and maybe the Deputy Minister who's with me is in a better position, having participated in some of those conversations. That wouldn't be part of what we're going to be talking about next week, but I know that it's an active discussion, and I've heard, for example, my colleague Jean-Yves Duclos discuss that, but perhaps if Mr. Tupper has something around Wellington Street per se that I haven't contemplated in the Rouleau Commission finding, if you're okay, Madam Chair, perhaps the Deputy Minister could add something?
Simply to add that indeed conversations have been ongoing for some time. I would split them in two categories. The first is the definition of the Hill Precinct and how it is defined and what boundaries are set to it. And the second is how is it policed and maintained. I've been involved in the second part of those discussions. They have been across jurisdictions, and we have been trying to develop advice that can be brought forward to make sure that we have the cleanliness of lines of reporting and the ability to respond faster in the future.
Very much. My subsequent question is to Mr. Vino. As I look at the witnesses, you're the only one that's been here before. Is there anything in your previous testimony that in hindsight, if I can quote Mr. Justice Mosley, hindsight is apparently important in judicial practice, anything that you would wish to add or comment on?
Thank you, Madam Chair. Mr. Senator Harder, I do believe that what I personally have taken from the Commission of Inquiry, from Commissioner Rouleau, it's sobering in terms of something very important that took place in our country. As Director of CSIS, our job is to look at the threat that we're facing. And unfortunately, you know, this Commission of Inquiry, the work you're doing, and what we've been talking about is just demonstrating that, you know, the threat that we face in our country is getting more complex, is getting more pervasive. And so I welcome these discussions because I think, you know, we need to do more to be able to protect Canadians. So that will be my own takeaway, if I can put it this way.
Thank you very much. If I have time, my last question is for Minister Virani. I appreciate that you're reluctant to get into matters that are before the courts, shall I say. But I, for one, very much favor the action that you took in terms of appealing the ruling. Is it possible for you to give me a little bit of some of the legal questions that you feel are important to have the court review? I referenced, perhaps sarcastically, the evidence in hindsight. Is that one of the principles of administrative law that you would like clarity on?
Thank you, Senator Harder, for that question. What I can do is it's given that the litigation is underway, is I can sort of direct you to the notice of appeal, which has been filed, which is a matter of public record, and there's issues of law in terms of the standard of review that was applied in this context and whether the standard was correctly articulated and correctly applied. There's issues that relate to evidence, and there's issues that relate to the constitutional findings of the federal court. But I would just reiterate that obviously while we have tremendous respect for all of the courts in this country, there are concerns with this particular decision, and based on that we are pursuing an avenue that is available in Canada, which is the appeal that we've filed.
I move to Senator Smith.
Thank you, Chair. Question for Minister LeBlanc. Following up MP Green. In his decision, Justice Mosley noted that it was responsible for the government to be concerned about economic impacts of the blockades, and in a very broad sense, it could be considered, quote, threats to the security of Canada. Justice Mosley also notes that it's very hard to define what national security means. As MP asked, in what ways will this issue be fixed? How should we define what national security does mean?
So, Madam Chair, thank you, and thank you, Senator Smith, for the question. That is an issue that the government has reflected on since the invocation of the Emergencies Act and since, obviously, the Rouleau Commission findings. As I said, the government's intention was to respond publicly within a year, as we'd committed to doing, but the court decision that you quoted gave us a few weeks of extra work to reflect on that very issue. We had said at the time, and I remember my colleague, the finance minister, before the Rouleau Commission herself, saying that we thought that the economic security of Canadians was not the sole determining issue, but was part of a broad-based government conclusion that the security of Canadians was threatened and there was a state of public emergency that had been achieved, had been reached. Those were the discussions that the government was having at the time, and certainly when I spoke to Premier Ford, when I spoke to Atlantic premiers who were worried about pop-up demonstrations at other border crossings, the Premier of British Columbia had spoken to me in light of some reports that the Pacific Gateway crossing might be blocked. So you had other first ministers in another order of government across the country, from the Atlantic coast to British Columbia, with a lot of focus in the province of Ontario, telling us that they had, and their police forces were telling them, that there was a real risk of sort of a contagion of these economic blockades, and they were expressing very publicly and very privately to us the concern that the government needed to bring every possible instrument to bear to bring these situations to a peaceful conclusion.
And if I could ask one more question, the timing of the acceleration of the threat, how was that handled amongst the various players, not only from the federal government, but the provincial governments and the forces on the streets? How was that handled?
So, Madam Chair, perhaps, I don't know if it's the Commissioner or the Director of CSIS, perhaps can add, because they participated in some of those discussions. Certainly Director Vigneault was in his job and was in some of those same meetings as I was at the time, or the Deputy Minister. I know that as a government, we looked at a threat picture across the country based on what we were hearing from law enforcement partners across the country. And as I said, there was, and this was publicly available reporting, an increased risk of sort of a contagion or a spread. That was one of the important factors we considered, but I don't know if the Commissioner or David wanted to add something.
Yeah, Madam Chair, very briefly, Senator Smith, the way that the system worked at that point is very quickly the different levels of law enforcement and intelligence got together through joint teams. We had a team here in Ottawa. There was a team in the province of Ontario as well that was stood up with the OPP. And the purpose was to share in a very dynamic way intelligence and information to understand. So from a CSIS point of view, my people at the table, their job would have been to bring in intelligence about the threat actors that we were concerned with and be able to get get information from law enforcement to inform our own investigation. And so that very dynamic process was taking place at the officials levels, law enforcement and intelligence, in Ottawa, but also in the province of Ontario. And that information was then fed up to the incident response group that Minister LeBlanc referred to earlier, so that the cabinet, represented by the members at the IRG, would receive that information and that advice.
Western Canada, where you had a major dust-up west, was that part, they were part of that?
Absolutely. So, for example, at this point, the RCMP, my RCMP colleagues and the Canadian Border Services Agency had people on the ground who would be reporting right away to Ottawa in terms of what was happening. And then, that information is analyzed and then, reported back up. And then, depending on the situation, CBSA or CMP, in some cases, CSIS, would take, specific operational measures to be able to address the situation at the same time as we're providing information and responding to advice requests from the government.
Colleagues, we have time to move to the second round. We will have 4 minutes for Mr. Motz and Mr. Nakvi, and then 3 minutes for Mr. Fortin, Mr. Green, Senator Harder, and Senator Carignan. I believe that will bring us to a close, and so I'd ask Mr. Motz to begin for 4 minutes.
Thank you very much, Chair, and thank you, ministers and witnesses, for being here. I've been here as well all this time. I've studied as much information as I can at this committee and outside of this committee on the invocation. I still believe more strongly today than I did in 2022 that the circumstances to invoke the Act were not met, the threshold was not met, and in fact agree with Justice Mosley on his decision that it was in fact illegal and unconstitutional. That is a binding precedent, unlike Rouleau's particular ruling. Now, the other thing that I think the Canadian public need to understand is Canadians expect their government to follow the law, the rule of law, and not create an interpretation thereof that is convenient for the government to circumvent the existing law. And, Mr. Virani, you had indicated that, there are hundreds of years of precedent for lawyer-client privilege. And, the relationship has lasted hundreds of years. And you know what else has lasted all that time? For Parliament to make laws of the land which govern the people. And by invoking the Emergencies Act, the Cabinet gave itself the power to pass criminal laws which Mosley found to be unconstitutional. Now, my question to you is, have you actually found and read the infamous broader interpretation? Yes or no? That the government relied. Have you actually read the legal opinion, the broader interpretation that the government was telling everyone that they relied upon to invoke the Emergencies Act? Yes or no?
Mr. Motz, I'm trying to be helpful, but even answering that question would disclose solicitor-client privilege, which I cannot do here. But what I would say to you is that
let me stop you for a minute. You obviously can you answer me the date stamp that was on that?
Mr. Motz, in terms of solicitor-client privilege,
okay, so you can. The reason I asked that question,
the questions you're asking me,
yes or no,
disclose the
you've already
privilege.
answered. It was a yes or no.
Remember, excuse me?
Yeah.
Remember, we have interpretation. Please
it was
don't
a
talk
yes
over.
or no question.
Please don't talk over each other.
Mr. Virani, I don't believe for a second that the broader interpretation even existed when the Emergencies Act was invoked at the time of the invocation for a number of reasons. And, it wasn't really until the just weeks before the Reload Commission was about to begin that we all of a sudden heard about this broader interpretation, that it somehow magically appeared. And it's really quite disturbing that this broader interpretation is there now, and no one's seen it. No one's heard it, apparently. Mosley didn't get an opportunity to have it as part of his disposal, and neither did Justice Rouleau, who indicated that the evidence that he found to support the government's invocation was weak at best, and that anybody else could have come to a completely different conclusion. He was disappointed the government withheld that. So one of the questions that I've had for a long time is, who actually is the client and you're hiding behind solicitor-client privilege. And why is it so difficult to, is it the government? Is it of Canada? Is it the governor and council? Is it the prime minister? Is it the attorney general? In your opinion, who is the actual client in solicitor-client privilege in this particular case?
In this particular case, the client is the government of Canada, and what I would say to you is
Who
the
is the
same thing I
people of
said.
Canada?
It's the same thing I said to Senator Carignan, which is that there's nothing to hide, but there's everything to protect. And what my job is to protect basic principles about the administration of justice. Solicitor-client privilege is fundamental to that system,
Well,
as the Supreme Court has opined.
Well, we're just getting wound up.
I know. Mr. Nakpi.
Thank you very much, Madam Chair, and I want to thank my colleagues, both ministers, to be here. In fact, this committee has gone this so long that we've got alumni now coming and visiting and presenting at the committee. So great to see the Attorney General here. Look, every time I'm in this committee, I get more and more frustrated. Somebody who represents downtown Ottawa by the collective, at times, amnesia of committee members in terms of how they've forgotten what members of my community in downtown Ottawa went through. Just let me remind you that that convoy, that occupation of downtown core lasted for 1 month and 1 day. That is 31 days of downtown Ottawa completely blocked with trucks of all sizes, most of them running 24/7 with just bellowing diesel fumes in the air. Not to mention, as I may remind all of you, and quite a few of members stay in downtown, they honked all night long for almost 31 days until a court order had to be received. In that entire process, I think some of you may have forgotten that there was violence, there were hateful messaging and insignia to the point that there's always also a witness of a Nazi flag during that convoy. People of different backgrounds, especially racialized people, were harassed. There was an order of emergency that was declared by City of Ottawa, which failed to put an end to that protest. There was an order of emergency that was declared by the province of Ontario that failed to end that occupation until the federal government took action through the invocation of the Emergencies Act. To this day, the trauma in my community is real. Just a week and a half or so ago, the second anniversary, quote unquote, was celebrated, where protesters were in town. I heard from so many constituents of mine who thought about leaving their homes again because they were scared and concerned, because the trigger that caused to them. So while members has the convenience and the luxury of sitting around talking and debating solicitor-client privilege in this committee, I do want to remind all members what a community where people live, where businesses usually thrive, went through. And all and any action was necessary to put an end to that occupation, not to mention what was starting to happen across the country, whether it's the Coots border crossing or what happened in Windsor. So my question is this. I found, and I'll start with the Attorney General. I found it quite amusing that even Justice Mosley, in his ruling, stated that if he was making a decision at the moment when these things were happening, he would have invoked the Emergencies Act as well. Can the attorney comment on that particular sentiment, and how does that factor into the appeal that he has filed, among other issues? And I know he may not be able to go in too much detail, but I would like to hear the consideration that he took into account in the notice of appeal that he's filed.
Minister Vrani, you have about 10 seconds to answer.
I think matters of evidence and the evidence that was used to inform the decision and the timing of the decision are squarely at issue in the notice of appeal.
Thank you. We'll now move for 3 minutes for Mr. Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. I'd like to come back to you, Mr. Leblanc. You're the only one who was in the room at the time now. I understand you're not going to show us the legal opinion. And we're always served the same argument to justify the invocation of the act, but I understand we're not going to see it. Now, one of you, I think it was you, alluded to consultation with the provinces. Do you remember the result of that consultation? The day the government went ahead with the invocation, we only have a few seconds. I don't want to be rude. Yes, but I was speaking informally with different premiers. Forgive me, let me rephrase. The law says you must consult the premiers of provinces. Absolutely, yes, I was part of that discussion with Mr. Trudeau. So, do you remember the result of that consultation with the different provinces? Yes. Is it true that only 3 provinces agreed? Ontario, Newfoundland, and BC. All the other provinces said no. Yukon, Nunavut, and the Northwest Territories did not respond. Am I correct? I would have to check the notes. Well, I'm looking at them. They're your documents. I know you don't have them with you. You weren't prepared to answer those questions. You said so earlier. I didn't say I wasn't prepared to answer any questions. Yes, you're right. It was about something else. Yes, I would never say that I am not prepared to answer your questions. I have a lot of respect for your wisdom and your intelligence. That's why I was surprised that you didn't remember. But how is it that after a consultation, after a situation like what Senator Carignan described, that nobody was left in the streets, the blockades had been dismantled, what was in that legal opinion? What in the world was in there for you to decide to invoke the act? I'm very comfortable with the decision. My goodness.
Madame la Présidente, mon collègue avait quelque chose d'extraordinaire à
My colleague had something incredible to say. I would love to hear something incredible. I just wanted to say that the decision that was made to declare a state of emergency was conferred by a vote in the House of Commons, which was also the decision made by the Prime Minister.
Mr. Varani, you identified that the Government of Canada is the client. Who's the solicitor?
I'm the solicitor as well as the people that assist me. Or my office.
And you're also part of government.
That is correct.
You're in cabinet.
That is correct.
Yes, so you're both the client and the solicitor.
I wear different hats at different times in this context.
I remember the S&C, the details of the S&C Lavalin affair well when a previous Attorney General made a very clear distinction that there is some significant challenges about being both the client and the solicitor, and yet your testimony here today is that the sacrosanct feature is to protect the relationship, but the government has a long history of waiving competent confidence. So how do you defend that when most, as my understanding of the legislation that provided you with public interest immunity, weighed the balance of the protection of government information with the public interest? Having spent so much time on this committee, would you not agree that it is within the public interest to provide the most amount and the highest level of transparency and accountability to the Canadian public, given the fact that the purpose of us being here is on one of the most extreme points of legislation, namely the Emergency Act, sir? So being both the client and the solicitor, please explain to me and the public how you justify not providing basic information in the general public interest.
So let me clarify something. I think it's important for Canadians watching to understand that the Minister of Justice constantly provides, as the Chief Law Officer of the Crown, advice to Cabinet and to government.
I didn't ask for that clarification, and the round is mine.
That is my job.
I need you to actually answer the question I put to you.
I'm trying to answer the question, Mr.
We don't need a history lesson. I want you to answer the question I put to you.
So it is possible for the Minister of Justice to wear different hats around the Cabinet table. That's the first point. The second point, sir, is that I don't agree with your assertion that Cabinet confidence is regularly waived. I know of very few instances, actually, that it has ever been waived. And in terms of ensuring transparency with this process, I'm trying to provide you with as forthcoming information as possible. You've been provided with what is effectively similar to a charter statement. You've been provided with information from the previous Deputy Minister, François Dague. We are assisting you as best as possible without
that suffices.
Reaching the important
with my 20 seconds left, I would put to you that the average person watching who heard you talk about the sacrosanct relationship with yourself will not be willing to accept the answers that you've provided here today. And ultimately, I don't think further the public interest of the investigation that we're trying to do. Thank you.
Senator Harder.
Madam Chair, can I respond to that?
My time's up.
Time is up. Senator Harder.
Minister, let me donate the first part of my time to your response.
I think the Canadians that are watching right now in response to Mr. Green would appreciate that the Chief Law Officer of the Crown takes very seriously the issue of how the administration of justice unfolds in this country, and protecting solicitor-client privilege is something that I'm duty-bound to do, not just as Minister, not just as Attorney General, but in terms of my oath to the bar.
My question is for Director Viano. When you were here last, you talked about the emerging threats and the changing threat profile. Could you comment further in terms of the elapsing 2 years as to whether the trends that you forecast are altering, and if so, in what way? And what should we as parliamentarians be concerned about in the area of public safety and security and racially motivated and religiously sponsored terrorism?
Thank you, Madam Chair. Senator Arthur, unfortunately, my answer will not be a very positive one. What we have seen in the last 2 years is an increase in violent extremism in our country, both motivated by ideology, but also by religious motives. And that has accelerated also since October the 7th, the attack by Hamas on Israel. So we have, unfortunately, here in Ottawa, we've had, a terrorist plot that was thwarted because of the work of CSIS, the RCMP. And so from an extremism point of view, we have seen a rise in religiously motivated violent extremism. We also have seen what was the concern during the convoy, the ideological motivation continue to increase, both in terms of its people who are motivated against, so anti-government motivation. We have seen an increase in that. We have seen people who have continued to engage in planning, in prepping for activities, doing military-type drills.
And do you have the adequate authority and resources to respond to that increased activity?
So we have been working with the government and with Minister LeBlanc to provide advice on potential changes that would be required. And I'm not sure if the minister has views on that for the committee tonight, but there is indeed a lot of work being done to make sure that we all have the right tools. at our disposal. And I would just maybe add, in terms of foreign interference, we have continued to see an increase, and there is a commission of inquiry underway that will hopefully provide Canadians and House of Commons and the Senate, with some perspective on how the threat has continued to evolve and essentially make it more difficult for Canadians here.
And Minister LeBlanc, will that be part of your announcements of next week?
Through you, Madam Chair, Senator Hart, no, the specific resourcing of CSIS, for example, or some of the statutes, particularly the CSIS Act that's 40 years old, as some parliamentarians know as well as I do, is legislation that we think might be modernized to reflect the threat profile the director just referred to. As you may know, we announced consultations in the fall around looking at modernizing the CSIS Act, so that will be a separate parliamentary process, obviously, with the Senate and the House of Commons. But we as a government, and based on the advice of the Commissioner and the Director, recognize that the threat picture and the threat landscape is evolving in a negative way, as the Director said, and our job as a government is to make sure that the security services have all of the resources, including legislative and regulatory authorities, to do the work that we ask of them.
Senator Carignan, you have the last round, 3 minutes.
Moi, il y a une question qui m'embête, c'est...
There's something bothering me. Why did you seize the bank accounts of protesters? What was the objective there? And where did you get the idea to do so? I'm trying to imagine in what kind of free and democratic society in the world it is possible for the authorities to seize bank accounts for protesters.
There was a freezing for a temporary period of time in the assets that were then unfrozen.
OK. Donc, à quel endroit on freeze ou on gèle des...
So where are bank accounts frozen, which means that people can't actually spend the money in their bank accounts? So you're removing their goods for a period of time. Where is this done with no judicial authorization for the sole reason that those individuals are protesting in the streets?
I think, Senator Carignan, after 2 years on this committee, I think you probably know the answer to your own question, that we were dealing with a situation